Hello and welcome to Down the Middle. I'm Michael Thomas, your host, and as always, I'm so pleased that you're able to join us. Before we get started with this edition of Down the Middle, I just want to remind you that we have an email address. And after each show, hopefully you'll run to your computer and email us as to what you liked about it, what you might not have liked about it, and perhaps some recommendations for future programming. So far, we have gotten some pretty good comments, and I'm hoping to get more. The email address is downthemiddlemt@aol.com. Again, because I want you to get a pen, pencil, or crayon, or chalk, or blood, whatever you can write it with, downthemiddlemt@aol.com. The down the middle, and then MT, of course, stands for Michael Thomas. For our show, this edition, we are venturing into an area that people have asked about. That's one reason I mentioned that. Different folks have said, we should have something on like legal issues. Said, Mike, can you do that? So what I've done, I've searched around, and for one aspect of the law, I've gotten one of the most highly regarded attorneys in our area. He's a Connecticut attorney, and he has handled literally hundreds of matters in the criminal court. And I know particularly for young people, you want to watch out if anything should happen that puts you in that criminal court. So I want to welcome our guest, Darnell, and he's going to, Darnell Crosland, and he's going to speak about various aspects of criminal law. And also, as a special treat, have a former guest who's going to act as co-host. He's someone that many of you will remember from episodes in the past, and I'm very close to him. In fact, he's my son, Michael Thomas. So you get Michael Thomas Sr. and Michael Thomas Jr., and we're going to discuss things with Mr. Crosland. Darnell, I'm so happy you can make it.
Thank you for having me, Mike.
Yeah. So you heard me mention your terrific qualifications, which all your clients, of course, are very aware of that. What I'd like you to do for our audience, some of them perhaps have never seen you before, to just give us a brief idea of the type of law that you practice and basically where you practice it and how long you've been doing that, just so we get some idea.
Very well. Again, thank you for having me on the show. Whenever I come on these type of shows, when I first arrive at the studio, it's always hard to kind of determine what direction we're going to go in, but it always gets fun and goes by so quick. So let me speak quickly. In the beginning of my practice, I was at the Bronx District Attorney's Office, and I was in the area, the grand jury area, and that's when the cases first come into actually our office. I then moved to what they call the DAT area, which is desk appearance tickets, and those are for like lower level crimes. Many of the marijuana possessions in New York are violations, and so we process them through what they call a desk appearance ticket process. So we did that. I did that, and then I moved over to what they call the asset forfeiture division. And the asset
that sounds dangerous. Taking away somebody's assets.
Well, it sounds dangerous, but actually that was the more civil unit of the criminal environment. The reason why I say that is because in New York you have the penal code, and then you have the civil law code, CPLR, civil practice laws and rules. And what the asset forfeiture division did was they will use the CPLR
That's the civil practice law and rules?
Correct.
Okay.
They'll use that particular branch of the process to seize goods that were gained from, say, drug dealing or other illegal activities.
So that's how they get those Cadillacs or Mercedes or Lexus or Lexi, I guess you get more than one.
Correct.
And other property.
You might see the DARE cars running around, those supercharged Dodge. It has DARE, which is the Keep Kids Off Drug program.
Oh, really? Yeah, I've seen that. Okay.
They get those from that.
Okay.
When I was in the Bronx,
those, the city or the state or whoever, the DA's office doesn't have to actually go out and spend money to acquire that. They get them from our, I was going to say our good friends, the drug dealers, but I don't want to say that.
Exactly.
But they're the friends of the department and giving them these properties.
The necessary elements among
the necessary element. Okay, that's a good one. I like that.
So we try to coexist, and one of the ways we try to coexist is they may pay for their crimes on the penal side.
Okay.
And then
jail.
exactly jail,
or probation or parole or
and
whatever.
then any of the goodies that they've acquired over time through these illegal activities, we will seize that and put that to good use for the benefit of a larger society, such as the cars, computers, whatever they may have
that's
purchased.
interesting. Okay.
So it worked out well. So after I left the Bronx District Attorney's Office, I got a job in Connecticut with a judge at the Superior Court, and as soon as I got up there, I figured if these parking spaces are going to be available every single day, this is not a bad gig.
That's good.
So I moved up to Connecticut, and then since then I've left the court clerkship and opened my own practice where I do primarily criminal law. I still do a lot of federal litigation in New York and the Eastern and Southern District where I'm admitted.
Oh, you do? Okay.
Yeah,
So the
exactly.
Eastern District is the court that is in Brooklyn.
Exactly.
They have a new courthouse, relatively new, I guess for the past maybe 2 years old or something like that.
Yeah, they just christened it with the 100 and something mob guys who got picked up the other day.
Oh, right. Okay. I read that in the paper. Some of our members of our audience probably have read that.
Yeah.
Got a few bad guys off the street.
Yes.
Okay.
They put the new courthouse to use.
Right. That's good.
Yeah, and then Southern District, down 100 Center Street area.
Right. Down there. Okay.
So pretty much the federal courts obviously take you all over the place, but I pretty much practice in Connecticut, and my office is in Stamford, Connecticut, which is only 20 minutes up the road from here.
Right. Okay. That's good. That's good. So you had the New York experience,
Yes.
being with the prosecutor's office, the district attorney, and now, of course, working for the judge. What judge was it in Connecticut?
I worked for Judge Kevin Tierney.
Okay.
For the longest part, and then also I did some family work with Judge Harrigan.
Right. I see. Okay. I know they'll be happy to hear their names mentioned when they see their colleague now, a former clerk with the office.
Well, I'll tell you a joke about Judge Harrigan. He told me.
Is it a joke we can tell on there?
Yes,
Okay,
we can.
good.
He when I decided to go out to private practice, and I said, what are the benefits? He said, the benefits are simple. If you go to work for someone, you have one boss. If you go out to private practice, you can have 99 bosses.
Yeah, that's true.
And if one of the clients don't like you and they fire you, you still got 98 left.
Oh, that's a good one. I like that one. But you got all these people to answer to.
Yes,
When that's the case. Now, you mentioned, I'm going to let Mike answer a question, eventually. But, when he's with his dad, he has to, sit on the side for a while.
Defer.
But defer. You mentioned violation. And just so you can explain for those who may not be aware, a violation, perhaps as compared to a misdemeanor, as compared to a felony. Perhaps just break it down a little bit.
Well, a violation, first let's go from the top. Crimes are classified in this country as misdemeanors or felonies.
Okay.
And a misdemeanor is anything that's punishable by up to a year in jail. Anything more than that is a felony.
Okay.
And violations are obviously infractions of the law, but don't rise to the level of a misdemeanor or felony.
Something like a disorderly conduct may be a violation?
Well, it's some Connecticut,
Some
for instance, a
jurisdictions.
disorderly conduct would be a misdemeanor.
I see, okay. In New York, it's a violation.
You'd be a violation.
Punishable by up to 15 days in jail or some
Right.
modest fine or something.
And depending on what marijuana charge, if you just have a
Okay.
couple of joints, that might be a violation.
A joint being
a joint.
everybody knows a joint.
A joint is the colloquial term for
A little stick of
marijuana.
Okay. So a couple of joints, a couple of those little sticks could be
A violation.
a violation, all right.
Depending.
All right, so and then the misdemeanor you mentioned is punishable by up to
Up to a year in jail.
Okay. Now, as far as the types of cases that you handle now as a defense attorney, what's been the range of what you've been dealing with?
The type of cases that I deal with from a defense attorney will run the gamut. It could be something as simple as a breach of peace, which we just talked to. Breach
Okay.
of peace, disorderly conduct, sort of the same thing. Kids go to a party, come out, maybe talking loud in the streets, perhaps even joking around to a level that causes a disturbance in the community. They come and they might get tickets for that, and I'll handle those.
Right,
And
okay.
it goes all the way up to rape. I just did a couple of month trial on 2 counts of rape, 1
Oh, it took
count
a
of
few
kidnapping.
months.
Yeah,
Okay.
few months with the jury selection process.
Okay, all right.
And the jury selection process, for the audience who doesn't know, is every case that you try, you have to impanel a jury if it's
Okay.
going to be a trial by jury. And that process is sort of tedious in Connecticut because we have voir dire, which is individual voir dire, which we interview each and every citizen on the panel separately to see if in fact that person qualifies to be on this panel. When I say qualify, somebody may be brought in through a jury pool, and when they come in, they find out this is a rape case that we're trying, and they may have been a victim of rape in the past,
I see.
and they may not be suited for that type of
Right,
thing. So
okay.
we have to ask certain questions to elicit whether, in fact, we may have a conflict.
Now, those questions in that selection process, say in Connecticut, that is a questioning by you and I guess the prosecutor on the other hand, or however many defense attorneys are there of that individual for each one of the prospective jurors.
Correct. We take turns. So, for instance,
Okay.
if Michael's sitting as the prosecutor, he will have a chance to say, good afternoon, Mr. Jones. My name is Michael Thomas. I represent the state of Connecticut. I have a
Okay.
couple of questions to ask you, and they might, where were you born? What do you do? What kind of books do you read? All these kind of questions may seem kind of crazy,
Right,
but
right,
they're
okay.
they're geared to what kind of books you read. If you're reading books that may be sort of show the philosophy that you may be against a certain maybe race of people,
Right, okay.
then that may not be this may not be a panel if you have that particular race that these books are talking
Right.
against.
Okay. Yeah.
So-
Say if the person says, "Oh, I'm a firm reader. Each week I read another chapter of Mein Kampf or whatever."
Right.
Something like that, or at least in other things you ask whether someone might be a teacher or it might be an electrician.
Correct.
Or in Connecticut, I guess it's like in New York now too. It could be a judge.
Yes.
It could be the governor of the state or whoever
Yes.
that could sit on the panel. Okay. Now, when you said they individually, just so the audience is clear, is that you interview them each individually, but with the other prospective jurors sitting there, or is it individually, like in a room by themselves?
In a room by themselves.
In a room by themselves.
Correct,
That is
yes,
different than
yes.
New York, as
Yes,
you well know.
New York puts everybody together and sort of goes through the selection in a group.
So it is time consuming.
Yes, it is.
Each one, right? Okay. Did they get nervous?
Some of them do. Some
Right.
of them do.
Okay. In that room alone, they
Because
got
they-
these guys looking at them.
They're
There's
in
a judge there.
They're in a courtroom, and the judge is on the bench.
Right, okay.
And the veneer person, we call them.
The veneer. Okay. That sounds like a nice term. Veneer.
And that the veneer person is just a prospective juror at
Right,
this point.
okay.
And that person sits in a witness stand, which you see on television all the
Right.
time.
Oh, I
and they
can
sit
see.
right beside you. So for the very first time, they're sitting in a witness stand.
Right. I see.
know.
Yeah, that could be intimidating.
That's
Yes.
interesting. Is the court reporter there for that? Taking
Yes.
a record of the
100%.
proceedings?
Yep.
Excellent.
Yeah, because as I say, just as a comparison for those who may have been on jury, and I'm certain there's been members of our audience that have been on juries in New York, as compared to Connecticut, you have normally, especially if it's some type of major felony, you probably have about 40 prospective jurors sitting throughout the courtroom, and then the box is full of the other prospective jurors, maybe 12, maybe 14 or whatever, and you just ask the general questions. So the people that are sitting there that are not in the box, and they're sitting in the jury box as compared to the witness stand, which makes a difference.
Right,
in the way
and
a person might
we use
feel.
that exact number almost to the T. We bring about 40 people
About
in the
40
morning.
people, okay.
They all sit in the jury box, and then the judge may ask a couple of preliminary questions like, you heard the dates of the trial. It's going to be between May 5th and May 10th.
Okay.
Does anybody have a conflict with those dates? And if they raise their hand, the judge will say, what's the conflict?
Mm-hmm.
And then after that, they'll take them all out into the jury room in the back and bring them in one by one for the individual voir dire.
Right, I see. Okay, so they get the pre-screening basically in the beginning once the court announces what the actual dates and things like that. If they've already planned their vacation for 2 years, or they got
Correct.
their daughter getting married, or whatever on those dates, then at least they could come up with their
Correct.
excuse. Some of them.
Correct.
All right, so it's interesting. And then, so after that process, you pick the jury. Maybe just go a little bit through what would happen next after you, in the case that you had, for example, not getting into specifics of the case.
Correct.
But you pick the jury, and then
So-
the
so-
opening statements and everything. Once there's everything's,
Connecticut, unlike New York, we don't do opening
you
statements.
don't do opening statements.
Yes,
Okay.
correct.
Go right to the evidence.
Exactly. The prosecution goes immediately into proving it, putting on their case.
Okay.
So once the jury is impaneled, the judge will let them go, tell them what dates we start. They will come back. Normally, it might be a week or two later before the start.
Oh, really? So they have that gap
Yeah.
in between sometimes.
Right, because you got to remember that picking the jury might take 2 weeks. So
Okay.
you may get one jury person today. They'll get a little pass.
A
Now they
slip.
can leave.
Okay.
And now we still have the process of picking. So when we get to the end, then the jury is picked. And
Okay.
then it may we do this far enough in advance because we know it's going to take a while. From the time you get your first panel member to the time you get your last, it's going to be a
You
gap.
got, like, as they say, fortnight,
Yeah.
Okay, in between. That's good.
So that's
Interesting.
why you made sure to include the impaneling process and the voir dire in your discussion of how long the trial takes.
And in my fees.
And if you- well, yeah, oh, I like that part. Now, Jordan, say you have a client, a very nice young fella who may be charged with some serious felony, anything from burglary to rape or whatever. Now, while you're picking the jury, are they sitting there watching this?
Absolutely.
Okay, so they have a right to be there.
They have to be there.
They have to. Under
That's
the
a
law.
court date.
Right. Okay. Oh, okay.
Yes.
They can't be out,
No.
partying and anything. All right. Very interesting. So I know Mike may have some other questions because I've been hogging the whole.
I
deal.
appreciate that, Mr. Thomas. But I have to realize I'm sitting with two experienced trial attorneys, so what can I say? What would I expect? I wouldn't expect otherwise. But I did want to ask you, as we go through the discussion of a trial preparation and the trial itself, what's become your favorite part of the trial experience, if anything, over
That's
the
a
years?
good question.
And it's a good question. Good questions are always the hard questions. There must be some connection here. And whenever people get stuck, they like to say, "Good question." What's so good? I'm stuck.
I'm stuck, right. I don't know what to say.
That's what's good about it.
I didn't think about that.
Yeah,
before.
exactly. Good question. We'll buy a little time. So, well,
Experienced trial lawyer, you're good at that,
I'm
right?
telling you. So I think, obviously, again, good questions are one that makes you think. And I'm thinking, what's my favorite part of the process? I want to say when...
Not guilty.
You know what?
I nailed it.
You know what? You nailed it. You nailed it. But the window between arrest and when the jury goes back to deliberate and they come back with guilty or not guilty, it seems like forever.
Yeah.
And that's probably the worst part of the process because now's the part where you're double thinking. I should have said this or should have did this. And
I shouldn't have brought that witness on.
Exactly.
I should have brought that witness
When you
on.
sat for an exam and now you're waiting for the grade.
Right.
Exactly.
Kind of plays on waiting for your bar results. So
Exactly.
Okay.
You want to go
All
back
over
in
again.
and erase something.
Right.
That's a good point.
But you may not need to erase anything.
Right.
You might have done it perfect.
Right.
But it's just that time. And then, so you so correctly stated the favorite part is obviously when the jury came out and says not guilty. And I'll tell you what happened in this last case. Normally, the jury foreperson is supposed to give the judge a note with any
I
questions.
see. Right.
Any
Oh,
questions.
okay, right.
If they want to request a read back or something like that, they'll give the judge a note. In this particular case, the jury sent a note into the judge after 3 days of deliberation.
3 days.
3 days.
That's a substantial time.
Exactly. Went straight through the weekend and took a
Right.
couple of days. Meanwhile, I'm losing weight.
Listen,
The
It wasn't during the playoffs, was it?
No, it wasn't.
Okay.
So this trial ended in October,
I see.
and around
Okay.
October 3rd-ish. So the jury sends a note to the judge, and on the note, would you believe what the note said?
Is it trick or treat time? Halloween?
No, the note said, as to the first count, rape in the first degree, not guilty. Second count, kidnapping, not guilty. Third count, not guilty. That was the note.
That's the note.
Normally, the jury is supposed to send a note into the judge saying,
We
"Your
have
Honor,
reached a verdict."
We have reached a verdict. You got it." And then the judge would come in, bring all the jury members in, and say, "Do we have a four-person? Yes, four-person stands up. Four-person, do you have a verdict? What do you say, ye," or whatever they say.
Right.
And the four-person would say, "Yes, we have a verdict," and they would read the verdict. This particular case, we all sitting in courtroom sweating. The door knocks. The judge comes in. All rise. Everybody comes in. Judge says, "Bring the jury," and the jury comes in. Judge says, "The jury has given me a note," and the note says, "Rape not guilty, kidnapping not guilty, and rape not guilty." And we all look at each other like, this has to be a joke.
I see.
Because the four-person didn't get to read the verdict.
That's right. Yeah.
And then so my client looks at me in shock and amaze and says to me, "Is that good?"
That's funny.
I said, "I think that's as good as it
Good,
gets."
good, yeah. The judge is telling you not to get. That's interesting. That's good.
Yeah.
Did you still poll the jury? Did anybody?
Oh no!
You weren't going to poll the jury.
Oh no!
You get the heck out of there.
Yeah, you get that. You get out of there. You don't want that to be translated in any other language.
You say, "Dave, let's go.
Let's go.
Hit the door." And,
That's it.
yeah, that's about right. That's good. I never heard of that one before.
Yeah.
See, well, of course, in New York, as Mike knows, and obviously as you know as well from your experience, you do have that opening statement, the closing statement. At the end, you have a closing statement?
We do have a closing
the closing,
statement.
okay.
And that's when you get to have little liberties and you get to do some fun stuff.
I had a trial one time. The judge had been a civil practitioner for the most part. And I'm sorry, back it up. He had been a criminal attorney for the most part, and this was like his first sort of big civil case that he had. And we had gone through the whole civil trial, this, that, and the other. So he came out, and I won't mention the judge's name. Nobody will tell him either. But he came out and started giving the charge to the jury before the closing statements. And I remember I had to cough and hit and say, "Oh, excuse me, Judge." And he's like looking at me all angry. So I walked out. I said, "Judge, just one thing." So what's that? He said, "We didn't do any closing statements." So then I said, "So what do I do?" I said, "Well, all you do is say, I'm just giving like a preliminary idea what I'm going to tell you after these closing statements." So
you gave him a heads up.
Rescued him, yeah.
Yes.
Because he looked at me, he started sweating. He said, "Well, I said he got all like excited because this is his first time giving this type of
So
thing.
he jumped the gun a little bit.
He jumped the gun, yeah.
And it's funny you say that because a lot of people who lecture lawyers at these workshops, they tell you one of the job of the lawyer is to protect their judge.
That's true.
So so what you're doing,
Don't make them look embarrassed.
No, you're protecting your judge, helping them out, and any good judge will protect counsel as well.
Correct.
Some judges just lambaste you,
Yeah.
but any real mindful judge would know. We protect them and they protect us. That doesn't mean we do anything that's unethical.
No,
It's just that we want to present ourselves in a proper way, and if there's any way to show some courtesies, we should do that.
Yeah, it's usually best because for the public, it's best to see everything done in the proper fashion.
Correct.
Rather than to deal with things that may go off the target a little bit, and at least it can be corrected, especially
Right.
when it's something like
Right.
that. So that's very interesting. And now, in terms of you've mentioned how it goes with the jury selection with the trial. Now, let's back up just a little bit, way before you get to jury selection. When you have a young person come into your office, and or an old person for that matter, that's been picked up or ready to be charged for some type of crime, let's say it's a burglary, how would that have proceeded? What would have happened before you got the case, for example? Just so somebody knows.
That's a good question. If you don't mind, I'll take it. I'll back up a little bit in answering that, because I think it's very important for the audience to understand one thing. The police officers have a job to do. They're not mind readers, and they don't make the final decision as to what your faith is. They come into your life based on the observation they may have made.
Okay.
But those are very small cases. Right. Most of the time, the police comes in your life because some other individual has called the police and made a complaint.
I like the way you said that. They come into your life. I never heard of it expressed that way. That's very good.
It's really what it is.
Mr. Crosland, you got a good way of expressing it, but go ahead.
A lot of people don't want them in their life.
Well, of course not. Sees them at the door, they go out the window.
Exactly.
Back window.
Some neighborhoods more than others.
I know. Some neighborhoods, they start shooting them. Pop, pop, pop. But who knows?
Let's go to the videotape.
Let's go to the videotape, right.
So when a police officer gets a complaint from someone saying XYZ happened to me,
correct,
or XYZ thing was told happened, whatever, they have to take that report and do a little preliminary investigation. At that time, they make a decision of whether they want to make an arrest or not.
I see. Okay.
Sometimes they make an arrest that's not a proper arrest, but the time to deal with that, whether that arrest is proper or not, is not at the police station. It's not on the side of the road. It's not, in your driveway. It's in the court of law.
Yeah, don't start fighting.
Exactly.
Don't start taking out weapons and everything if you can avoid it.
Allow the police officer to complete his process.
Right. Okay.
Whatever that is, and that's the best way. And now the best thing you can do for yourself, and I think I have to, look directly and tell the people is, remember you have the right to remain silent. It's no disrespect to the police. A lot of times people feel that if I tell the police, you know what, I'd rather remain silent and I want to get a lawyer, they feel the police is going to look at them as though you must have done something wrong because you're not talking.
Right, okay.
And it's just like if your mother will call a mom will call a child into a room and say, what happened? The child feels, I better start talking first, because if I talk first, then my point will be more stronger than the person who talks next.
Right, okay.
But in the criminal justice system, that doesn't work. It doesn't work that way. Anything you tell the police can and will.
You're saddled with those words later.
Yeah, exactly.
What you say is it lives for the rest of the case.
Whatever you say, I think the Miranda rights is can and will be used against you. Right, yeah. Let's just go ahead and step that up. Whatever you say will be used against you.
Yeah, skip the can.
Can. Forget, that's a capability question.
Will most definitely.
I like that. Will most definitely be used against. So you can say respectfully to a police officer, I understand you have your job to do. I'll give you all the pedigree information you need. My name, my address, my date of birth, all that stuff. But in terms of my position on what happened here, I'd rather do so with counsel.
Okay, very good advice, very good. Now, let's say the next step after that, say if a person is arrested, and then they'll be taken in front of a judge at some point.
Correct. It's called the first time everybody has to come into your life. Let's stick with that.
Okay,
thing.
coming in. Okay.
So the next step is a judge will come into your life.
I like that.
and this step of the stage is called an arraignment.
Okay.
That's the first time that you're brought before the court.
Just charges just rain down on you. But go ahead.
And the judge at that point has to make some decisions. Excuse me, not of guilt or innocence,
Okay.
but of what type of bond, if any, will he set.
Okay.
And also, at the arraignment, the judge will place conditions on release if he does release you. So if there's a particular case of, say, a gang situation, the judge may listen to the prosecutor, listen to the defense, and say, okay, I'm going to release you, but one of the conditions of your release is not to associate with these people or these members
Okay, so
or co-defendants.
right, okay.
I may put an ankle monitor on you. Whatever the judge feels protects your safety and the safety of the community, those are conditions the judge may put at arraignment.
Okay.
And then after arraignment, the judge will set it down for another court date, and at that point is what they call pre-trial negotiations. And those are negotiations with the state or the people. We call it state in Connecticut. In New York, they call it the people.
Okay.
You may negotiate with the people and figure some things out. You may be able to settle it, and the people may present to the judge, Your Honor, we have a settlement. Or if you can't, then you proceed to trial, which we discussed a little while
Right.
ago.
Okay. Good.
Yeah.
Now, is there a point in Connecticut? I know in New York we have, and you're familiar, of course, with that. But the grand jury will indict somebody on a criminal matter.
No, in a federal court.
Federal court,
in federal
okay.
court in Connecticut, because it's the same as everywhere else. You
Right.
have the grand jury. But in New York, it's been a minute, but I believe they impanel a grand jury just like a jury. We talk about jury. They have to find jury members and
Right.
do all that. They do all that, then they impanel. And people are always shocked when I tell them this or when they hear about this, especially in Connecticut. But those grand juries are impaneled for sometimes months at a time.
Yes. Yes. Okay.
Because they hear many presentments, if you would. They don't hear actual substantive cases. They hear the prosecutor or if in federal case, the U.S. attorney putting on their case,
And they'll have
their
witnesses
charges.
come in, that'll say, I heard so-and-so say this, I saw so-and-so do that. Okay.
Exactly,
All right.
and the defense the defendant has a right to be present, but not a right to be heard.
Right.
And so that will go on for a little while, and then the grand jury will say, well, we have enough to return. I think they call it true bill,
Right.
which means that they have enough to go forward. And the joke is that a grand jury would indict a ham sandwich.
Well, I was going to say that phrase. There was, I don't know if you're such a young fellow, you may not remember, but there was a well-known person versed in the law that used that phrase. Say, the grand jury or prosecutor get them to indict a ham sandwich.
Exactly.
So it's your chances are not too great.
No.
Now, is it ever that we're drawing to a close? Would you believe it? We've
Already?
been having a good time. Yeah, we don't
We
have
didn't
much
talk
time left.
cross-examination, direct examination.
Well, you know what? There'll be another time, another place, or maybe this place. We'll
Maybe
have
this
you come
place.
back.
I would love to do that. There's
you
so
do
much
it?
to talk about.
Okay, it's good.
And this is stuff that people don't really get to understand until they're in the process. And,
Right.
And so this
And sometimes
type of
it's too
form-
late.
It's too late at that
Right,
point.
it's too late, yeah.
Too late at that point. And it's fascinating. You look at your television shows. They got Harriet's Law now. There's so many shows about law because it's
Right.
fascinating.
Right, yeah,
The
it's
producers
just
in
good.
Hollywood wouldn't produce these shows if it wasn't interesting.
No, that's true.
So I'd like to be back on Down the Middle, and let's.
Well, thank you. Say that again.
I'd like to be right here and on Down the Middle.
Okay, I don't have to indict you to get in.
No, Down the Middle MT at AOL.com.
Very good. I appreciate it. Well, thanks a lot.
Thank you so
Darnell.
much.
And as always, thank you, Mike.
Thank you.
Thank you.
Thanks for having me.
Once again, we have appreciated our guest, and we thank him, Mr. Crosland, Darnell, and co-host Michael Thomas. And remember, as I always say, whenever Down the Middle is on, we want you on us. We love to have you and can't wait until we see you again next time. Thank you so much. Good, thanks. Yeah, oh, good. It was perfect, man. I mean, you terrific. We have to have you on once a month. At least, yeah. Now, I did want to arrange, we can sort of get the show up in Connecticut.
Yes,
maybe
that's
within
the
next
goal.
couple of weeks.
So that these
All
can
you have
air.
to do is
Local.
you have to check with a local cable service, whatever, and they have procedures. Each one is